All right, good evening, everyone. My name is Paul Cohen. I'm town manager here in the town of Chelmsford. And first off, welcome, and thank you for taking time out of a very busy time of the year and to join us in our, what we're calling an orientation meeting and development seminar. The select board, in recent years has really placed an emphasis on updating its policies and procedures and onboarding new committee members and really being a source of assistance to committees in town, because as we've seen in recent years, particularly the complexities of local government and how to manage and preside over meetings and committees has been ever changing. And we've seen some recent court rulings, and some of that will get discussed later this evening, and how the impacts of running hearings and public input and so forth. And we're blessed this evening to have our representatives from our new Town Council, KP Law, with us at the table. To my left, closest left, is Michael DiOrtenzio, then Lauren Goldberg, who's the principal partner at KP Law, and Joe Fair, who's sort of been an ongoing assistant to the town of Chelmsford and is our principal counsel for KP Law for the firm. And you'll also, and many you've already had in your capacity, have interacted with other representatives of the firm. And I think you see they have a very deep bench and they have expertise. And one of the beauties, and I believe when the select board selected them as counsel, is their experience in basically with dozens upon dozens of other municipalities in Massachusetts. And so we've sort of yet to find anything that they haven't quite experienced that's unique to Chelmsford, but they bring that perspective to help us in our needs. And again, in their first few months, we're sort of wading through some of the issues and really have off to a promising start. And I think the next prominent place you'll see them will be at town meeting next month as we convene our fall annual town meeting. But for tonight's purposes, again, we want to welcome you, thank you, and really the bulk of our time this evening is going to be hearing the presentations from council, but it's also meant to be interactive and for a discussion, and hopefully you come away with some insights and some thoughts on how we can effectively administer our responsibilities and sort of navigate the landmines that are out there in today's world. So with that, I'm going to turn the podium over to our town clerk, Tricia Duras. Tricia has, if you came in the back of the room, there is a orientation committee guide that many of you may have had when you came on board in the community. It is updated, and so again, please feel free to take one when you depart. And so Tricia's going to speak to sort of some of the preliminary aspects of that. Following that, our select board chair, Pat Wojcik, will have a few remarks. I'll then come back with a couple of oversight issues, and then we're really going to turn the floor over to council for the bulk of our time this evening, because I think the areas that they're going to provide insight on will be very helpful. So without further ado, I'll turn it over to Tricia.
Good evening, everybody. As Paul said, I'm Tricia Duras. I'm your town clerk, and I see a lot of very familiar faces in the audience. Is there anybody here that is brand new to a board or committee? All right, great. Thank you for being here. Have you by any chance gotten sworn in to your oath? Excellent. Okay, I can skip right over that part. But basically, just for information, any new board or committee member is appointed through the select board or the town manager, well, from the town manager or the select board at one of their meetings, and they get from that office an appointment letter. And you bring in the appointment letter to the town clerk's office, and you get sworn into your oath of office to perform your duties. And since everybody here has been sworn in already, that's a wonderful thing. We do ask that if there's any changes to your contact information, that you please alert the town clerk's office so we can update our database. And if, as you start meeting with your group, anytime your committee reorganizes, please make sure you let the clerk's office know what the new positions are, who's the new chair, secretary, treasurer, whoever you may have. Again, keeping that database up to date is really important so that the community knows who to reach out to when they need to. The next item I'm tasked with is how to post public meetings. So It seems redundant to us because we say the same things over and over again. But before you post an agenda with the clerk's office, can you please be sure that you have reserved a meeting room? Because it's really hard for us to double check and make sure that the reservation has been made or that the room is available. We want to try to avoid conflicts. So you go to the town website, so it's chelmsfordma.gov/facilities, and if you're charged with booking that room, make sure you book your room before you submit your agenda. Because one of the essential items that you have to have on your agenda is the date and time of the meeting, but also the location and the meeting room. So that has to be part of the agenda before you post it. Meetings need to be posted by 48 hours, excluding Sundays and holidays, weekends and holidays. You don't have to wait to the last minute to post it. If you know what your agenda items are, please post it as early as you know that. It gives us a lot more time to react. We do ask that you please, if it is just at the 48 hours, that you send it to the town clerk's office before 1 o'clock that day. We don't want it at 4 o'clock when we're trying to wrap up our day. So as a courtesy, if you could please make sure you send them to the town clerk's office by 1 o'clock on the last day that you're able to post. We prefer that agendas come to us via email. It would be townclerk@chelmsfordma.gov. That's where agendas should all go to. That is a joint mailbox with everybody in the office, so that way if the person whose main responsibility for posting agendas isn't in that day, anybody can pick up that duty without any hesitation. It's also your responsibility to double check and make sure that that agenda has been posted on the calendar. So again, right on the home page of the website is, on the lower part of the page, you scroll down, is the board and committee calendar, and just double check and make sure it's posted. And if it isn't, then you contact the town clerk's office right away. We only post what we can get, and we only post what's sent to us on a timely basis. I do have to put my glasses on for the rest of this so I can see. The other thing that is mandated that you put on your agenda is a list of topics that are reasonably expected to be discussed at the meeting with sufficient details to advise the public of the general issues to be discussed. And any revisions can be done as soon as possible, please, but no later than within an hour of the meeting. All right, are there any questions on posting a meeting? We do have a template on our website as well. So if you go to the town clerk's page, there's on the left-hand navigation, it says meeting notices. We have our meeting procedures right there. Or you can use your handy-dandy orientation book. And there is the select board's policies in there. And also just on page 7 is all the information you need about posting meetings. Any questions? Okay. All right, so filing meeting minutes is also a requirement, and public bodies must create and maintain accurate minutes of all meetings, including executive sessions, and minutes are not intended to be a transcript of the meeting, but must accurately record the meeting logistics, any topics discussed, and actions taken by the public body. Meeting minutes must have on them the date and time of the meeting, a list of all members present and members absent, and summarize each topic as discussed by the public body. Exact wording of any motions that are made and seconded. Any decisions and actions taken, including a record of all votes. Votes in executive session must be recorded in minutes by roll call. List of documents and other exhibits used by the body at the meeting, and where exhibits and documents may be reviewed by the public. Those are all required to be in your minutes. When your minutes have been drafted and approved by your board or committee, and they're ready to be posted, please again send them to townclerk@chelmsfordma.gov so that we may, as a courtesy, post it to the town website. Again, that's transparency. We like to get those minutes as soon as possible. The law requires that it has to be within 3 meetings of that public body or 30 days, whatever is later. Okay? Is everybody clear on what a timely fashion is? Yes?
For recording who's there, do you have to record the public?
You do not have to list who is there in the public unless you're going to allow them to speak, then I would.
Okay, so if they do end up speaking like in front of the group.
Yeah, I would ask them to state their name and their address usually, and what their comment is about. Okay? Any other questions? Cool. My part's done. All right, thank you very much. I think I just picked up your papers.
Oh, that's okay.
You don't need
I've lost my script. Our next presenter is Select Board Chair Pat Wojcik. She has some introductory remarks and again can answer any questions you may have from the Select Board perspective. Pat?
Thanks, Paul, and it's wonderful to see so many people here this evening. It's good that you're interested in learning how to conduct a better meeting. I'm sure you can never know too much about how to run a meeting. As many meetings as I've gone to and tried to run, I learn something every single time about things I can do better. So I just have a couple of topics I want to talk about. First, being liaison assignments. We have probably 50 committees in the town of Chelmsford, and we have, I think, over 40 that have a liaison either assigned or a person on that committee who's a voting member. So that still leaves a few that we don't have any liaisons to, and if you're one of those committees and you want to have a select board liaison, let me know and we can assign one. The liaison is typically assigned by the select board chair shortly after the select board reorganization and after the town election in April every year. And it's important to know the responsibilities of the liaison. That person is not going to come to every one of your meetings. As you can probably imagine, with 50 committees and 5 members of the select board, each select board member is going to be responsible for 8 to 10 committees, and we can't make it to every single meeting that you hold every month or however frequently you meet. But if you have something of interest that you think the town or the rest of the select board should be aware of, you can reach out to your liaison select board member, and they will give that information to the rest of the board. And as far as expectations, as I said, don't expect us to be there for every meeting, and don't expect the select board member to be able to answer every question that you might have if they do come to your meeting. They're not there as part of your committee. They're there basically to observe and to bring back information to the rest of the board. So one of the functions of the select board every year is to establish goals for the town manager and the select board and generally the entire town. And we typically do that either in July or August. So for this fiscal year, I'll just briefly tell you some of the goals that we've set for ourselves and the town manager. We have, top of our list is fiscal management and visibility, so that the entire town is aware of what the financial situation of the town is, and I know Paul is going to talk about that a little bit. And some of the things that we're going to reevaluate is our fee structure for issuing licenses to see if maybe we can generate a little bit more revenue that way than we have in the past. There's always grant opportunities that we'd like to apply for, and we generally are pretty successful, I think, in that regard. We're never going to get every grant that we apply for, but I think we've had a pretty good track record as far as that goes. We've been very fortunate, actually, that we have 3 state representatives and 1 state senator, and every legislative year we ask them to remember us when they're deciding on earmarks to submit to the legislature. And we've been, I think, very fortunate too, since we have 3 state representatives, that we generally get at least 3 earmarks, which is very helpful for the town. We've had a request to reconsider marijuana sales in the town of Chelmsford. That's something that we'll do some more research on and see if it makes sense to bring that to town meeting at some point in the future. And you're probably aware that we received over $10 million in American Rescue Plan funding as a result of COVID. We are very close to allocating all of those funds, which has to be done by the end of this calendar year. I think we have about $7,000 left of that $10.5 million that we have not programmed so far. So hopefully we'll find a place to put whatever we have left there. And we get monthly reports on how those funds are being used and how much of the funds have been expended. We have some ideas about process improvements that need to be made just in general, some gap analysis and reporting on projects and metrics. We'll get quarterly updates on those. We just set these goals last month, so there's still some information that we need to find out exactly what we want. I'm sure you've heard about the sewer situation in the town. We've come close to our capacity, so we're trying to go through some prospects to generate more capacity by inflow and infiltration reductions. That it's probably more complicated than I need to go into this evening, but if you watch our meetings, you'll learn probably more than you ever wanted to know about sewer and stormwater and drainage. Infrastructure, the highlights there are roads and sidewalks. We spend $4 to $5 million a year usually on roads and sidewalks, and you'd think that's a lot of money, but it covers maybe 10 miles, if that, of roads and sidewalks. It costs a lot to install a new road or sidewalk. People are always asking about underground utilities. I know last week at the strategic plan session, there was one suggestion that said we try to do more about underground utilities. That's also very pricey, and it's been difficult to keep progress going forward on that. Okay. Some of the town government focus areas, Warren Pole Reservation. We're working on a conservation restriction for that so that we can then give that to the Conservation Commission for them to monitor. We always have traffic issues. That's something everybody complains about, the traffic in town, but we try to handle those to do traffic calming measures as needed and as appropriate. We've heard a lot recently about our tree canopy diminishing significantly, so we're trying to come up with a plan to help to reduce the number of trees that are dying, and when we do have some trees on public property, ways to salvage those trees or replace them in a good way. And I mentioned a strategic plan. There was a big push, a big kickoff on that last week, and there's several upcoming focus groups on that. So if you haven't already, reach out and make your thoughts known about how you'd like Chelmsford to move forward. And speaking of boards and committees, we have several items on our goals that we want different committees that we want to help with what they're going through over the next fiscal year, including the Fire Stations Study Committee, the Open Space and Recreation Committee, Clean Energy and Sustainability Committee, Planning Board as far as the MBTA zoning support, the Housing Production Plan update, which we're helping the Housing Advisory Board with that. We have a school building committee. As you may have heard, we're in the pipeline possibly for a new school in the coming several years. So we have that. And you may have also heard that the country will be celebrating our 250th birthday within the next couple years. So the parade committee is excited about having something special for that. We have a few policy updates that we'll probably be talking about as a board over the next year, including town council appointment process and a town manager hiring process and timeline. Not that we want Paul to go anywhere, but at some point we know we will have to do that, and not that I'm looking forward to it, but we need to have a plan in place for how we're going to do that. And finally, I want to mention about volunteer appreciation. As I said, it's wonderful to see so many people here this evening. And I was on a webinar last week where somebody mentioned that as far as volunteers in boards and committees in Massachusetts, the value of that input is approximately $40 per hour for each person on every board and committee. And if you count up as I said, all the committees that we have in town, all the members of those committees, and it's not just a meeting once or twice a month for an hour or two. There's prep work you have to do. There's follow-up you have to do. So the number of hours is just astronomical. And I think it is time that we show our appreciation to the committee members. So we've been talking about possibly doing that in conjunction with the volunteer fair in the spring. So look forward for more information on that, and we're going to try to do something really special. So with that, I'm going to turn it back over to the town manager.
Thank you, Pat. So you see, there's a lot going on, and again, we're very fortunate, again, with your efforts and also the dedicated staff who serves for the community. And again, one of those products that you saw as you came in this evening was the committee guide. You know, we realize it's challenging, and I think the message that I can convey on behalf of myself and the people that I work with every day is, you know, don't hesitate to come to us. The last thing we want you to feel is either overwhelmed or frustrated or, you know, or uncertain in terms of what's the right thing to do. I mean, you know, we're a situation where, you know, we want to deal with the needs of the community and the public in a timely way, but we want to do it right rather than doing it rushed. And so again, the committee guide has information on that in terms of, as Tricia noted, about how things are appointed, you know, how agendas are, minutes, processes, and again, we're going to spend significant time very shortly in terms of some of the processes in terms of that may be of value to you as committee members. It was touched upon earlier by Pat that we've initiated the strategic plan process. We had the kickoff event last week over at the Elks. We had a strong turnout, and really we're looking to continue that over the next month in terms of getting input. And in fact, there will be 3 more community forums on the strategic planning process. You may have, when you walked in this evening, you may have seen the big cardboard cutout about the website and so forth, but to most note it, on Tuesday, October 8th, from 9 to 10:30 at the Chelmsford Center for the Arts, there'll be a forum session. There'll also be one on Wednesday, the 9th, from 6 to 7:30 at the North Town Hall, and then on Thursday, October 10th, in this room from noon to 12:30, representatives again from our strategic planning consultant and the town will be here to get community input in this room. We also have an online survey, there's an online discussion. This is your opportunity, and as well as we want you to spread it around. I know you've received mailings from me and then another mailing from me and probably a third mailing from me, and you'll probably continue it, and I'm posting on social media. We're looking to develop a plan for the next 5 years in terms of where we're going, because as was noted, there's a lot going on and our resources are constrained. And we know this is, you know, a time where the residents of the community are sort of looking to chart where do we want to be as a community? What do we want to preserve? What do we want to aspire to? Where is it we want to dedicate our limited resources? And so please participate and encourage others to do that. And for those of you who already have, you know, thank you. And also, again, you know, spread the word, please, because, you know, it's a significant undertaking by the Strategic Plan Committee, as well as the resources that town meeting has provided. And you'll see our neighboring town of Westford is about 6 months ahead of us. You'll be reading about and hearing about their strategic plan the months ahead. Other communities have done it, and obviously business and other aspects are doing it as well, because that it just helps us to navigate where it is we want to go as a community. So please participate in that process, like I said, in an online session or in person at these forums. And then lastly, I want to just touch about budgetary outlook. Tomorrow, my finance director, our finance director, John Souza, will be sending out to the town's department heads the budgetary instructions for the upcoming fiscal year. Even though we're only in the 3rd month of the current fiscal year, we're obviously beginning the process for the year that starts next July, which will be FY26. And the capital request went out last week, so we're obviously gathering information towards that process. The schedule is the same. With the requests are all due by the end of October. The Capital Planning Committee will hold its meetings in November and early December. In accordance with the town's charter and bylaws, I will release a proposed operating budget the end of January, which is basically 90 days prior to our spring town meeting next April. And the Select Board and I and others in Finance Committee and Select Board will be gathering later this calendar year, and you'll be hearing news. I mean, the reality is it's a very challenging time. You know, we're sort of met the challenges of the pandemic, and we're sort of coming off of the period of very high inflation. and we've all been affected by it. And it's really, and it's coming home. If you, again, it's the same realities that you have in your individual households. Wages, you know, we want to provide a fair and competitive wage for our employees. Health insurance, we're seeing staggering costs for health insurance. You see it in the state, the struggles of Stewart Hospital, the struggles of the Medicare system. We're part of that as well, and we're seeing the increases in healthcare premiums probably going back to around the 10% level as all these issues come together, and they're all interrelated. We've you know, when you see the situation that's out there with the nurses striking for better hours, more pay, you see the hospitals trying to be viable, you see the crunches on consumers in terms of prescription drugs. You also see the utilization rates, and particularly prescription drugs. The most notable one of these weight loss drugs, which are adding hundreds of thousands of dollars to its costs in our system, to the point where the Connector, which is the state's sort of program for those who can't otherwise get health insurance, their normal increase in recent years was like 3.5%, 4%. That's now doubled as a result of the utilization and the cost of prescription drugs and so forth. And then same thing with utilities. You know, unfortunately, the Massachusetts area is one of the highest utility costs in the country. We're at the end of the natural gas pipelines. You see the efforts the state is making in terms of trying to get wind power, or trying to get power down from Canada, hydro and so forth. It's because it's so expensive. And again, we've seen it in our aggregation rates to residents. We just bid our own for our 27 buildings for the community. Our rate went up 38% from the 3-year contract we just came off of. And why does all this matter? Not to mention our retirement assessments in terms of, you know, the retirement system does revised actuarial schedules every 2 years. Obviously, people are healthier, they're living longer, the costs are growing. They've also got this requirement under state law to fully fund their retirement system by the year 2040. It's almost similar to what you see with the post office and what you've seen with postal rate increases and so forth, because they have a similar mandate. And we're seeing our increase for this upcoming year is going to be over 8%, and then the following year is going to be over 6.5%. Why I throw around percentages and numbers is because in Massachusetts, we have a system that's called Proposition 2.5 that limits the growth in the property tax base to 2.5% plus your new growth from construction. Chelmsford raises and has raised to the levy limit, meaning we don't have any excess capacity. 77% of our budget comes from the property tax. So that's 2.5%. So if 3/4 of our revenue is coming up at 2.5% plus some variance for new growth from construction, but then meanwhile, inflation is driving wages above that, is driving healthcare above that, is driving retirement benefits above that, and utilities, and the same costs that you bid for, you know, whether it's food service in the schools for supplies or materials for DPW, whether it's fuel and so forth. That's the challenge we have in front of us. And unlike some of the wealthier communities of the state, Chelmsford doesn't have a history of operational overrides. We saw what happened in Westford, you know, just over 6 months ago. They passed an override at town meeting. It failed miserably at the ballot. We see the challenges most recently in Drake, where they didn't even try an override. They just made the cuts. We're not immune from that, and you're going to hear about this and see this in the months ahead. It's not a Chelmsford issue, it's a Massachusetts issue. I think you're also going to see it at the state level as well. And you've already seen that. When you kind of look at it, why the state has had that response to the migrant situation, it wasn't because the governor, in my opinion, had a change of heart. It's just because it became just financially crippling. But it's not the only financial challenge that the state has. So the issue was the state has sort of always been the life support for cities and towns, going back to the implementation of Proposition 2.5 back in 1978. The problem is that's a bigger challenge. And then even the services that you have. You know, I see our school committee chair here. Coming out of the pandemic, we have greater needs for the student development that was lost. And it even came out, if you saw the other day, in terms of the MCAS scores, which again, it's not the tell-all, but it is an indicator of the decline of achievement, and also the increased individual attention that needs to be for educational plans for individual students Those challenges are real, never mind the behavioral issues, the mental health challenges that we see our police department and fire department dealing with on an everyday basis. As you know, we are sheltering homeless people in the community and so forth. All of this creates a challenge for the community, and we have no choice but to meet the challenge and somehow navigate our way through it. So again, coming back full circle, that's why we need your input on the strategic planning process, and we welcome your input as we address these fiscal challenges and direction for the community in the month ahead. So again, thank you for your patience with that, and I welcome your support and as we address this. So without further ado, as I stated at the onset, we want to provide the bulk of this time to receive some guidance from council on some important matters that are affecting the community in terms of, as Tricia noted when she was going over the things about the open meeting law requirements and the posting requirements. Those changes have taken place. We've seen the state changes, as most recently the MBTA zoning. We're now sort of awaiting its arrival with the accessory dwelling units by right and single-family homes issues. So there's a lot going on, and the issues that are for the boards that have to navigate it, as well as your traditional responsibilities. We thought it was helpful this evening to have council sort of focus on 3 topics this evening. The first one is how to conduct an effective public hearing. Following that, we'll talk about public input at board and committee meetings, which again has changed as a result of court rulings. And then we'll also talk about First Amendment rights and public records concerns and such as a result of the whole challenges by communication through social media and other aspects of today. So with that, I'm going to turn the podium over to Michael, who's going to speak about the effective way of conducting public hearings.
Thank you very much. And good evening, everyone. It is a pleasure for us to be here. My name is Michael D'Ortenzio. I am with KP Law, who is your new town counsel. Of course, we have attorney Lauren Goldberg and attorney Joe Fair tonight as well. I want to start by thanking you. This is both for your time tonight and also for your service on a board. It is sometimes a thankless job, and sometimes you can run into challenges or complaints or people who are looking to criticize you for something that you have done. And what we hope to do with what we're going to be able to provide you tonight is to give you some tools to make sure that as you conduct your business, you work through your committee meetings, your public hearings, your social media postings, that regardless of what the policy is, wherever your board lands on the policy question, that you've done it in compliance with the law and you're protected from any legal issues during that process. So I have the pleasure of talking first about public hearings, and I'm going to try to make this as exciting as I can for everyone here. As I say, some of these topics we're going to bleed into each other, right? So if you have questions at any time, just throw your hand up or shout the question out. I know for Joe, for Lauren, for myself, we want this to be interactive, and what's most important is we want it to be helpful for you. All right, so starting with public hearings. So one of the things to know is that the open meeting law actually doesn't require you to take input from the public. In most cases, you conduct your business, the public gets to observe, but you don't actually have to hear what the public has to say, right? They either elected you or they elected somebody who appointed you to do your business. And so in the sort of representative democratic model, that is the public input. You make the decisions, the public speaks through the elections. But, and you'll hear us say often at the office, it always depends, right? And so what the legislature has said is that even though there's no general right in the open meeting law for the public to address you and to give you feedback, there are certain circumstances where the legislature has said, we really want the public to have a say. We want you to be forced to hear from the public on certain issues. And those are public hearings. And they happen in a variety of different policy contexts throughout the general laws. So I know we have the school committee chair here somewhere, and so good to see you, sir. And so you will, of course, I'm sure, have sat through many school budget public hearings. That is a special law that requires the school committee to post notice in a newspaper and to have a, quote, public hearing every year on the proposed school budget. I don't know if anybody here is on a planning board or a zoning board. Okay, I'm seeing some heads nodding, right? The Zoning Act, Chapter 40A, talks about public hearings in many cases. So you're going to look for a special permit, a variance, you have to have a public hearing. And there are many cases where the laws will just sort of put in the clause after a hearing, right? Your board can make a decision, comma, after a hearing. And so that's where the legislature, again, has said, we feel that this policy issue is of such importance that we want to make sure you hear from the public. So what we want to do today is to talk about how you execute a public hearing. And I've always found there to be some irony in that the legislature says you have to hear from the public, but doesn't actually specify here's how to conduct a public hearing, right? There's nowhere in the law that says this is exactly what you do when you hear from the public. And so what we're presenting tonight is really the best practices that we've developed over many years at the firm, working with a number of towns that we feel, one, provide a good platform for you to hear from the public, and two, give you protection in any future litigation. So the first thing I want to do is touch on the open meeting law, and Attorney Goldberg's going to speak a little bit more about this. But as I say, the open meeting law is always in the background, right? Whenever we do our business on a board or committee, any multiple member group, the open meeting law is something we have to have in mind. And when it comes to public hearings, there's a really key point, right? And that point is that the chair is always in charge of the meeting. So who's here a chair right now of a board or a committee? Okay, a lot. And so you are kind of in the hot seat. Not only have you had to plan the agenda, you've worked with your staff to organize the meeting and the packet. You get to the meeting and you've got to run the show. People are looking to you. And so it can be overwhelming, but what's important to remember is the law backs you up. The law gives you the authority to run the meeting. And so ultimately, that first sentence is what is key. No person shall address a meeting of a public body without permission of the chair. And so as we start here, I want to remind folks that sometimes you have to have a public hearing, right? But if you have someone who is threatening you, somebody is disrupting the meeting in the sense that the board can no longer talk to each other or hear, right? Remember, you as the chair are in charge. You can recess, you can ask an officer to come and assist. And so just remember that that is always in the background, that safety comes first. One other point just to note on the open meeting law is going to appear on the screen, which is that you make sure to inform folks that the meeting's being recorded, right? So most of your public hearings presumably are going to be broadcast on your local cable station, and so you just want to say at the beginning of the meeting that this meeting is being recorded, and we do have a number of complaints that come through at the office where somebody has forgot to say that sentence, and thank you very much for the thumbs up from Chelmsford Media in the back, and that can generate a complaint, and then we'll have to respond to the Attorney General, right? The whole point of doing these presentations is to really avoid our involvement, right? We want to be there to answer your questions, but we want you to be able to do your business without having any legal issues so that you don't have to call us. So again, Attorney Goldberg is going to talk more about the open meeting law, but I just wanted to put that foundation there for public hearings specifically. There's a couple of points on practical tips, which is what I want to get into now. Okay, so first things on the public hearings. Whenever you have a public hearing, you want to start by making sure you can have it. And so we have had situations before where a board will sort of go through a meeting and they realize they didn't have enough members there for a quorum. And that can sometimes happen when you have a board that has associate members, and when you're calculating the quorum can be a little difficult. So before you have the public hearing, right, make sure that you have your ducks in a row. Make sure you have your members at the table, you have enough of them. And then the second thing is to give an opportunity to explain where you are to the public. Most members of the public, this may be their first time engaging with town government. You know, particularly, you know, if you're, for example, speaking to the school committee, you may have a child in the school system for 18, 19 years, and they've probably been to school committee meetings before. But let's say it's a zoning board of appeals hearing. You got a postcard in the mail that your neighbor has filed an application for zoning relief. That may be your first and only time interacting with town government. you may not have been to a public hearing before. And so we find it's very helpful for the chair to take a few minutes, even if you're looking into an audience of familiar faces, to explain what this is. This is a public hearing. We're here to hear from the public and to receive public input, but we're not going to deliberate or respond to what you say. And we welcome you speaking before us. And again, as Attorney Goldberg will talk about when we come to more open meeting law, there are certain rules that you can set, right? You can say to members of the public that you only want them to speak for, say, 3 minutes, and Attorney Goldberg will talk more about that. Whatever those rules are, share those with the public when you start the meeting. Make sure that everybody has a sense of what the rules are before you get going. And that way, if you do have to cut somebody off, everything has been clear and transparent. A couple of other things that we recommend with public hearings, right? For many of these, you'll have to advertise them in the newspaper. Not all of them. It depends on the specific policy area and the specific statute. School committee budget hearing will be advertised in the newspaper. So read that aloud, right? You'll have a copy of the notice. Let the public know we have properly noticed this public hearing. It was advertised in the newspaper on this date. We're here for this purpose. For example, to receive input on the school budget. And set that framework before we begin. Okay, so next what we want to do is talk a little bit about some of the specifics on the public hearings. One specific is when it comes to remote meetings. Now I know some boards and committees are folks having remote meetings from time to time. Maybe not, maybe everyone's in person, okay. A hybrid, okay. So if you have any member who's remote, we wanted to emphasize this. This law currently goes through March 31st of 2025. We're waiting to see if the legislature extends it or makes it permanent. But this is very key because it also applies to your public hearings. The first is that if you have anyone who's participating remotely, make sure you announce the names of everybody who is a board or committee member, right? So the chair will just go through and say, here are the individuals who are with us at the public hearing today. You can just say their names. If you take any votes, for example, to open the public hearing and close the public hearing, you'll do that by roll call. And then finally, you have to make sure that everybody can hear each other. And usually, now that we've worked out all the Zoom kinks from early in the pandemic, that is just fine. Any questions so far on the general setup? Okay. All right, great. So let's turn to opening the public hearing. So 2 things we want to note to start. One of the things that you have to do with the public hearing is it's your time to hear from the public. It's not your time to deliberate. And so sometimes we see at the office complaints of cases where someone will say, well, this wasn't a public hearing, right? They received information, they started deliberating, there wasn't a clear opening, there wasn't a clear ending. And so in order to best protect yourself and to be able to say to any higher authority or a court, you had your public hearing and you did it consistent with the law, make it a formal process. Open the public hearing, hear from the public, close the public hearing. And that way, if there's ever any questions down the road, we can always go back to Chelmsford Media and we'll be able to show it to whoever has the question. So let's start with opening the hearing, just for a couple of tips. So first, proper statutory notice. Oftentimes, this may not be taken care of by you as a board or committee member. It'll be taken care of by a staffer or somebody else in your department. But make sure that you have advertised it properly, that proper notice has been given to any abutters, again, particularly in the zoning and planning context, and that you have complied with whatever those rules are for your policy area. That's the first thing when you're opening the meeting. And that's why we recommend just say to the public, right, this was advertised in the paper on this date. Also, the open meeting law, you heard from the town clerk earlier that you have to post the agendas 48 hours in advance, excluding weekends and holidays. And so when you're opening the meeting, again, you can state this was advertised properly. This is a public hearing being held under the open meeting law. We have posted the meeting.
Michael, that's 2 different postings or 2 different pieces of notice?
That is.
And you need them both?
And it's a great point, Attorney Goldberg, which is because either one can trip you up, right? And so if somebody is trying to raise an issue, they're going to file a complaint, they can say that you didn't post properly under the open meeting law, or they can say that you didn't properly post your public hearing. And so you've got to make sure that you have accomplished both, checked both boxes in order to successfully have your meeting. The open meeting law, of course, is not going to require publication in a newspaper. As the town clerk mentioned, those publications are done through her office. And so again, as Attorney Goldberg mentioned, to emphasize that one is not a substitute for the other. You have to make sure you check the public hearing box and you check the open meeting law box.
What was the 14 days last thing that was on the last slide?
Yes.
14 days.
So that specific example has to do with the Zoning Act. And so when you're providing notice under the Zoning Act for certain hearings, you have to provide that notice 14 days ahead of time to, it's usually interested parties, so people who live around a particular proposed development. That is specific to the Zoning Act. Different statutes, again, I was on the school committee in my hometown, so I don't mean to pick on you, but going back to the school committee public hearing, that may have a different time period on that statute. So the public hearing, in terms of how much notice you have to give, will vary depending on your policy area. Yes?
Just for the presenters, for the purposes of TeleMedia's recording, if any questions come from the audience, if you could repeat them into the microphone for the recording, that would be very helpful.
That's a great point. I appreciate that. And why don't I repeat that one that was just asked, which is the 14 days that's noticed on the slide, what does that have to do with? And it has to do specifically with the Zoning Act. Thank you for that. Yes?
Chelmsford doesn't have a newspaper locally. What qualifies it? Do you post things on the internet, or what do we do if the little sun goes out?
It's a great question, and actually a topic of debate at the office. And so one, I think we're hoping the legislature provides some guidance, right? Because a lot of these statutes are decades old and not reflecting the reality, unfortunately, of the local news business. The answer really depends on the particular statute, because different policy areas have different specifics. Some will say in a newspaper of general circulation in your county, right? So, Middlesex County, of course, very large, and so would provide you with a lot of opportunity. Some will say a newspaper in your town. Right now, that's the Lowell Sun. If there is no newspaper, we'll have to address it at that point. But it is, the internet at this point does not qualify as a posting location. The Massachusetts Newspapers Guild does take the printed notices. They have an internet portal where they publish them, but you also have to have them published in print. But again, that is an active policy area. Certainly the State Municipal Association has been, I know, lobbying on that. What the legislature will do, we'll have to wait to see. Thank you for the great question. Okay. All right, so again, in terms of the public hearing, the same rules under the open meeting law apply, and we wanted to emphasize this rule around accessibility. Because if you're required to have a public hearing and you're having a meeting that's not in an ADA accessible room, you're opening yourself up to a potential claim that we would like to avoid. And so one of the things to note is that you always want to be having your meetings in spaces that are accessible under the ADA, and so that's probably your traditional meeting rooms. So if for some reason all the meeting rooms are booked, you're looking to have your meeting outside or at a different location, contact your town clerk, your town manager, talk with them about it, right? And then we can get involved if need be. One of the issues is that you can hold your meeting under the open meeting law at any location. But again, if it's not accessible to the public, you have a potential claim that your public hearing was not validly held. So if you're going to have that hearing at some location that's different than normal, contact your town clerk, contact your town manager. And again, with the best practice, right, you may have a large crowd that shows up to a public hearing. And I've had some school budget hearings, right, where we'll have nobody there, and there's probably 2 people watching online. And some years, there's some blockbuster issue, and we've got 60 people in the crowd, and we had a room that only had 20 seats. And so it doesn't mean that you have to cancel your meeting, but you have to be really, really thoughtful about making sure that the public knows where the hearing is. And so the best practice is to try to keep it in the same space if you can. If you have to move the hearing, right, you have to ensure that the public has a way to know where it was moved. If it was moved down the hall, there has to be signage. Maybe there's somebody stationed who can direct people. And so this will happen at public hearings where more people will show up than you expect. And in the sort of, excitement of moving to a new meeting room, it's easy to lose track of having somebody stationed there and putting up signs. Really, really important. Because if somebody walks in after the room has moved, they don't know where it is, they have the ability to then file a complaint to say, well, wait a minute, I showed up to the public hearing. Where it was advertised, it wasn't there. So that's one thing to make a note of. Okay, so a couple closing points on public hearings. So the first one is everything has to happen publicly when you're in a public hearing, and also when you're deliberating on the matter. This is especially true when you have remote or hybrid meetings, because people may be more easy to pull out your phone and text, right? And so when you're at a public meeting, whether you're on Zoom or you're sitting here at the table, you can't communicate with your fellow board members unless you're speaking out loud such that the public can hear you, right? The public, under the open meeting law, has the right to know what's happening in a public hearing when committees are deliberating. So definitely don't send an email, don't text, don't provide commentary to each other over your cell phone on what that person said or what you thought about what this person's comment was, because that's the kind of thing that could be discoverable in a public records request and also could be an open meeting law violation. And so sometimes in public hearings, it can be challenging. You're having a lot of people come up. If this is a difficult issue, you may have a number of people yelling at you for, speaker after speaker. And it's very easy to send a message and put something in writing, just trying to let off some steam to your fellow board members. That, we have seen situations, has come back to be a problem. And so to remember, as difficult as it can be in some circumstances, you're there to listen during the public hearing, not to respond. That's not to respond to the public. It's also not to respond to your colleagues while the hearing is going on. Motions to continue are important, particularly in the zoning aspect, but if you're going to continue a public hearing, that has to do with a specific person. So I filed a variance because I'd like to build something on my property that the zoning bylaws don't allow. And you want to continue the hearing because you want to get more information or somebody's sick, whatever it is, get it in writing. That's the best way to do it. It's not required, but it's going to give you the protection to be able to say, we had the hearing, both sides agreed to continue it, so everybody is on the same page. Now, if you're at a public hearing where there's not another side, the school committee budget, right, the other side is sort of the general public, it's not a specific party. Usually we recommend that you try to have those hearings in one sitting, because you can't agree with somebody else to have a continuance. Any questions? Okay, so now finally, I think we have a slide on closing the public hearing. So, as we said, there is not a law that says here's how to have a meeting. And so these are our best recommendations. But when you have a challenge, you want to be able to show to a judge, the attorney general, that you had a formal hearing. So you want to vote to open the hearing, and then you want to vote to close the hearing. Again, if you have somebody who's participating remotely, that vote has to be by roll call. And so one of the things to note is that when you have a public hearing that's required, that's your time to hear from the public. So you can hear all the comments on that. You're not deliberating during the hearing. That's your time to hear from people. Once the public hearing is closed, in most cases, you should not be taking additional testimony or documents from the public. Now, this is especially true in the land use or regulatory context. So if you're on a Conservation Commission, you choose to have a public hearing, a zoning board, a planning board, right? Once you close the public hearing, you've closed the hearing. You're not taking additional information. If this is a school committee public hearing on a budget, you could take additional information at a future meeting. But generally, the best practice is to get the information during the meeting and then close it. Then it's the board's time to deliberate. The public had their opportunity to provide input, and that has now been closed. And that's a best practice to make it clean and transparent for members of the public. Everybody had a chance to come to the public hearing, and if somebody chose to come, that's great. If they chose not to, that's fine too. But having that formality is helpful. Yes?
If something were to come up subsequently in the meeting or after the meeting, but after the public hearing is closed, but before a decision has been made or even deliberation has been undertaken, is it appropriate or something that can happen to reopen the public hearing? And is that what you're saying we should not do?
So this is another. Thank you. So this is a very good question, which is if new information comes to light or somebody wants to reopen the hearing because something has changed, a circumstance has changed, are you allowed to do that? And the favorite lawyer answer of it depends on the situation, which is because the policy areas vary, right? So if you have a public hearing on a zoning or planning or a regulatory matter, right, where the town is in the position of issuing a permit or making a decision that affects a specific person, reopening the public hearing can be challenging. When you have a school budget process, you're not impacting a particular person's rights, but you're just trying to hear from the public generally. It's more easy to reopen the public hearing. But what we would say in those circumstances is contact your town clerk, town manager, and we can assist based on the particular policy area at issue. Any other questions? These have been great. And so, again, in closing, what we have is it's important to remember to have some formality to the hearing, right? Open the hearing, close the hearing, make sure it's advertised and posted publicly and properly under both the open meeting law and your particular statute. And hopefully public hearings will be able to do what they're meant to, which is it's an opportunity for the public to have their say. The meeting may be a number of people singing your praises. That's unlikely. It may be a number of people coming with complaints, right? But either way, the public had their say, and that means you've done your job as public officials to listen when the law requires, and then you are charged with actually getting to make the decision. And however that decision gets made, you can feel comfortable knowing you've done it correctly and you've complied with the law. So, again, thank you for your time. I hope I made that somewhat interesting. And again, if more questions come up, you can feel free to ask them at any point throughout the presentation. And at this point, I'd like to turn the mic over to our managing partner, attorney Lauren Goldberg.
Well, good evening, everyone. You've listened to Michael now for a while, so I don't think there's any hope of you thinking my presentation is going to be exciting. But I want to add just a couple of things to what Michael said about public hearings. I think it's important to remember that when a board or committee is acting in a quasi-adjudicatory manner, it's very, very important that the only evidence that you rely on during your deliberations is the evidence that's given during the public hearing. And so one of the kind of main things between a public hearing where we're just gathering information from the public and a public hearing where we're acting in a quasi-adjudicatory manner, as Michael said, in a regulatory matter, is that people have due process rights. And we can negatively impact those due process rights if we're texting each other, if we're actually like on our computers looking stuff up during the hearing. Everybody at the hearing, all of the people that are making the decision, have to make the decision based on the same evidence. So that's really crucial. And it's also, it's really important, especially if you're doing a remote or hybrid meeting, that if you're allowing the public to participate, that they have the ability to do so without any technological interruptions, especially if the applicant is the one who's remote. And so the AG has some guidance on that. And if you're concerned about what you would do in that circumstance, we're happy to point that out for you.
Lauren, quick question.
Yeah.
Oftentimes on a controversial matter, a board will get a flurry of emails on a topic. Do those all have to be read into the record, every email that a board receives on a topic?
That's a really good question. And Michael stole my line with "it depends," and it really does. It's fine for the board to say we have 10 emails here on this topic, and they're going to be part of the record without reading them all into the record. But if the board intends to use that for, let's say, a regulatory matter, then yes, they would have to be read into the record because we would need to utilize them for purposes of the decision-making. Not all boards will accept email input, so it really depends. And I think I'm actually going to kind of follow up where Michael left off, talking about the role of the chair, but it's important that the chair kind of make clear from the start, we either are going to accept email, written guidance, or we're not, and written input, or we're not. If you ever go to a city council meeting, I don't know if any of you ever have, they read every single email into the record. And so if you're there on a night when there's a lot of emails, you're there for a really long time. Anyway, okay, so part of what Michael was talking about with the open meeting law is part of what we refer to as the sunshine laws. And the sunshine laws are essentially an effort to make government transparent, to make it that the public gets to see what the decision-making looks like, so that the public understands what correspondence is being exchanged. That's the public records law. And the conflict of interest law, the law works to make sure that every single municipal employee, including volunteers, are loyal first to the municipality rather than to their own interests. And so all of the open meeting law discussion that we're having, and Joe is going to talk a little bit about that too, is in this context of being transparent and government transparency. And I think we all know that this issue, transparency, has been in the news for a number of years now, and there remains significant interest in being able to access kind of the wheels of government. And so municipal board members are under a much higher level of scrutiny, I would suggest, than ever before. And as Michael indicated, a lot of times that comes at you in unexpected ways during meetings when you really can't anticipate it. And so it's very important that the chair knows what to do with that kind of interaction. And the open meeting law actually gives the chair some tools to make those decisions. The first is that the chair is in charge. Some chairs, if you've ever seen a strict chair, literally nothing is said at that table unless the chair recognizes that person to speak. It's not required by the open meeting law that that level of formality exists, but it is often the case that that's what makes a meeting actually proceed through the business of the meeting rather than stopping kind of here, there, and everywhere. Under the open meeting law, the chair decides who will talk and when they will talk. And so if you've ever heard a chair say, so-and-so has the floor, like cut you off, that's why it's up to them. They get to make that choice. We're going to be talking about a new case from the town of Southborough called Barron v. Calenda. And in that case, essentially, the town of Southborough had a civility policy, and it required that you be, I would say, be kind to your neighbor, that you be polite, and that you not raise your voice or be rude. And the court said, too bad, so sad, board members. We're sorry if you feel attacked. Your job is not to sort through who's nice and who's not nice, and instead the First Amendment and I'm going to forget under the Massachusetts Constitution, different numbers, but they essentially guarantee people the ability to petition their government. And so we can't cut off someone that when we don't like what they're saying, or tell them that if they can't be quiet, they have to leave when they're the speaker, kind of thing. And we'll talk more about how to deal with that. However, a chair can enforce reasonable time, place, and manner restrictions. And that's really what we're going to talk about the rest of the time. So examples of that are limiting speakers to a certain number of minutes. It is to perhaps say we're only going to take public comment or public input at the beginning of a meeting or at the end of a meeting, and to require that people come up to a microphone to speak and that they don't just yell out from the crowd like you guys are doing. No, I'm just kidding. And so, each board might handle things differently. There's no law that requires it to be handled in a particular way, but there are efficiencies that can be gained from using some level of formality. We already talked about the chair informing people that a meeting is being recorded. This really came from a world where there weren't recordings being made all the time of every meeting, and instead what was happening is that people had their own little, and I'll use the word tape recorder. Some of you might still remember that. And they would come up and stick the tape recorder in the face of the person who is speaking at the front table. Very disruptive. Or they'd bring in one of their giant cameras and stand in somebody's way and try and get the best angle, which interfered with the meeting. These days, you can record with your phone, you can record with a pen. You don't need to disrupt the meeting to record, but you're still supposed to tell the chair. So rules of procedure, how many of you know about Robert's rules? Right, yes, everybody knows about Robert's rules. And what Robert's rules is meant to do is to facilitate the conduct of meetings, okay? It is not meant to make it impossible to speak at a meeting or to make a decision at a meeting, meaning you don't have to comply rigidly with every single thing that Robert's rules says. It's supposed to be used to help navigate disagreements or different perspectives. And so if your board or committee doesn't need that kind of assistance, meaning you are willing to listen to each other and people don't speak out of turn, and you're able to revisit something without making a formal motion, that kind of thing, then that's fine. You don't have to use Robert's rules. If you choose to, people benefit from having those ground rules, then it's fine to do that. Again, there's no law that says that you have to do it. Another issue that comes up with respect to public bodies and their meetings are, what does an individual member of a public body get to do? Who are they? And the real answer is that without the backing of a full board or committee, a single individual who's on a board or committee is just a person on a board or committee. They don't have the authority to speak for the board. They don't have the authority to bind the board. And it's really important that people understand that the power of the board comes through the votes taken by the board. And especially when you're dealing with perhaps commentary from the public, whether it's good or bad, individual members have no right to represent the board as a whole at that, to say, the board feels that is da da da. The board hasn't voted on it, so the board doesn't feel. And so as kind of, a good board member, a good citizen of a board, you need to remember that you really can only act by that consensus, by a majority vote. And so you may have different feelings than your other board members, and that's okay. But you are just a single member. In that capacity as a single member, I mentioned here that you have to do an open meeting law certification. You also have to do a conflict of interest law certification every 2 years, also when you're appointed, and then every 2 years. And if you're an elected official, and I'm just throwing this in to make Tricia happy, you also need to remember that being a good being a good board or committee member also means filing your reports with the Office of Campaign and Political Finance. You are so welcome. Okay, so codes of conduct. Codes of conduct are another way that chairs have authority to help facilitate meetings. And essentially, the Select Board has a code of conduct, which I pulled here to highlight. And essentially, it's that, members are going to understand what their responsibilities are. Boards can only act in their lane. They can only act consistent with the statutory scheme that applies to them. And so sometimes, it's important that all the board members are familiar with what that lane is. Only that action taken at a official legal meeting is binding. And again, we come back to an individual can't go to a meeting of another board and stand up and say, the such and such board takes the position that blah, blah, blah. That individual, as a private individual, who also serves on that board, can have a position, but the board itself can only be represented by the board's vote. No one can bind I'm sorry. Yes, you have a question.
At a previous meeting, a board decided that they did have an official position, and they wanted to announce that to other groups.
Yes.
And they already did their meeting, and they agreed as a board to have that position
Mhm.
to take to other groups. Is
Yeah.
it fine to announce that the board at another meeting has this?
Yes, so the question, just for those of you who might be watching at home, is that if a board has made a decision about something, is it okay for a member to then take that to other boards and say, the board has voted to do such and such? And the answer to that is absolutely. It's a board vote. The other types of things, obviously being respectful of one another. It's very hard to enforce codes of conduct, as might not be surprising. There's a civility clause in the current code of conduct, and again, this is really kind of an understanding of what a board or committee's obligations are, what the members are to each other. Another really important part of board activity is understanding kind of the difference between the policymaking nature of a board or committee and the actual day-to-day operations of running the town. The boards and committees have statutory authority and maybe regulatory authority. The charter sets forth the rights or the responsibilities of the town manager and staff, and so it's important to understand that there's a difference there. Being respectful of that administrative chain of command is really important. And then also, and this is something that comes up from time to time, is that when a board or committee member has an issue with staff, it is best to go through the town manager to resolve that. Staff ultimately is responsible to the manager, and so the number one, it respects the staff's work and their position, not to talk about their performance at an open meeting, but instead to take that to the administration to deal with there. I have some other examples of board goals and standards, and my hope was just that you might take a look at these as you kind of organize around your boards to try and decide, what are the chair of the select board talked about the goals of the select board, and it's useful for boards and committees to also look at kind of what their expectations are for each other as well. So going to the open meeting law, conducting the meeting, as we indicated earlier, the open meeting law doesn't provide for public comment. It doesn't favor public comment. It doesn't disfavor it. It doesn't apply, period. There is no right under the open meeting law for any attendee at a meeting to speak, or really even the other members of a board other than the chair. And this can be, I think, a bitter pill sometimes. People get really upset when they learn the open meeting law doesn't give them the right to talk at a meeting. But that's the way it is. The open meeting law does not address public comment. Nothing in the charter here requires public comment either. And so whether to have public comment is a decision. The select board has a public comment policy. I don't know if other boards and committees have their own or if they use the select boards, but every town has, kind of an ongoing relationship with public comment policies. As the manager indicated earlier, there has been recent case law that, and we talked a little bit about the case Barron v. Calenda. But what it's done, and there's also a case called Shirtloff v. the City of Boston, which is a flag case, and it's about whether the City of Boston had to fly flags that it didn't necessarily want to because it didn't like their message. And the bottom line is the courts are more and more protective of First Amendment rights. And so when we're dealing with it with public comment, when we're kind of opening the door to it, we have to understand what the implications are. So if we're, yes, go right ahead.
With regard to that, is it the chair's responsibility, or can we limit public input to what's relative to town business or what's on the agenda?
Yes-ish. The question was, can we limit public comment to what's on the agenda or that business? The answer really is yes to both of those. It's important, if you're going to allow public comment, that there are rules around public comment that give you as chair the ability to control the way the meeting goes. And so I've listed some of the considerations. You know, how long are we going to have public comment? When are we going to have it? What's it going to be about? How long will people be able to speak, and will people be able to speak more than once? And the reason that this all matters is that all of those things are what we would call reasonable time, place, and manner restrictions. It has nothing to do with the content of speech. In the Barron v. Kalenda case, the Southborough case, essentially the chair cut off a person who was calling the board members criminals and holding up signs that basically were accusing them of stealing from the town and generally being loud and negative. And the chair, civility policies have been in effect, in cities and towns for as long as I've been doing this, over 25 years, I'm sure much longer. And the chair said, you need to calm down. Essentially, you need to stop screaming. We'll have a conversation if you stop yelling. And the Baron wouldn't stop yelling or wouldn't stop being boisterous, as the chair believed. And so the chair actually said, we're going to take a recess, and you can see him kind of on the video yelling at her and swearing at her that she needs to stop. And the court looked at this and basically said that chair did everything wrong, that the chair essentially tried to cut off a person who is being negative but allowed all of these other people who are being positive to speak as long as they wanted, and that people have the right to petition the government. And part of that conversation in the case is about the kind of breadth of people's ability to be critical of government, and that being a fundamental right that has been really important in the United States, which we all know is true. In that discussion, one of the things that the Baron, the plaintiff, did is she called the chair a name that probably most people would find to be a significant insult and inappropriate. And the court basically said, yeah, that wasn't a problem. And so it really highlights that the kind of speech that can be curtailed is very limited. And so I'm just gonna skip all the way past this, Joe, up to, since he's kindly doing the slides, what is disorderly conduct? Yes.
I had one quick question. I don't know if you can say this succinctly enough in this presentation, but could you explain the difference between government speech and community speech?
Yeah. Of course. The question was, can I differentiate between government speech and community speech or private speech, and what the difference is? So the government has the ability to adopt policy positions and to take policy positions, especially the select board, because it's responsible as a chief policymaking entity of the town. Individual speech or private speech comes from individuals, and it essentially has a higher level of protection under the Constitution. So when we talk about speech, we look at different public fora or forums. Joe, you're going to talk about that, I think. So I'll leave that to him. But you have more protection in an open forum. So when the government says, come in and speak to me, speak to us, and we're going to hold a public hearing, we're not going to put any limits on anything. when we do that, we're giving that speech from the public a significant level of protection, making it harder to control. And so one of the things that we suggest, and actually, Joe, we'll go back to the one before, is, why have a public comment policy? What's the point of that? And the point is to be able to have control over that conversation. Okay, public, you can come and talk to this board about anything within the board's jurisdiction, or anything that's on the agenda. So that's one way of doing it. Another way is to set a duration for the comment period. We're going to spend 15 minutes with public comment. And at the end of 15 minutes, even if someone's in the middle of their sentence, we're cutting them off. Where do we want to put the public comment period on the agenda? We're gonna do it at the beginning. That first 15 minutes comes and goes, and that's it. Are we gonna put it at the end? Are we gonna allow public comment with respect to different items on the agenda? Let's see, what else? Not having people that are there to talk at a public hearing also speak during public comment. We can restrict them like that. We can restrict the number of minutes that each speaker has, so 2 or 3 minutes, depending on the number of people that are present. And we can also prohibit public comment at any other time when we haven't allowed it. And all of those restrictions are reasonable time, place, and manner restrictions that have nothing to do with content. We've seen this play out in situations where there is a very controversial issue going on in a town. There'll be a public comment period at the beginning of the meeting. There might be 15 people that show up and want to talk. The policy is that when there's more people there, that each person then can fit within the 15 minutes, that each person gets 2 minutes. And at the end of that time period, that is it. That 15 minutes comes to the end, and that part of that discussion is over. As compared to, as you can imagine, listening to people saying great things in response to whatever's going on, and then coming to a person who's perhaps particularly negative about the town or about something that the town is doing, and the chair saying, you know what, we're done with public comment now, we're just gonna move on to something else. That's based on content of speech, not based on a reasonable time, place, and manner restriction. So by saying we're gonna talk for 15 minutes, whether we like someone's speech or we don't like someone's speech, that speech is over and we've protected ourselves. Yes?
You said that there's only 2 minutes per person, and then one person, the chair says, they let them continue beyond the 2 minutes. They don't enforce the timer. Is that something that's you have to be concerned about?
Yeah, so the question is not enforcing these time limits a problem? And it is. The second that you add discretion in, you create potential liability. And I want to be clear that the potential liability is significant for violating this type of civil right. There is potential liability for the town, but there can also be potential liability for individuals for violating civil rights. So having a policy like this protects you and it protects the town, even if you feel somewhat uncomfortable doing it. And I think Michael made a really good point earlier that I'll reemphasize, which is setting out the rules for the conversation at the beginning of the meeting means everybody is on the same page. And I've actually heard a chair, chairs say, we have 15 minutes for public comment. We have 7 people that want to talk. I'm going to give every person 2 minutes. When we're done with the 2 minutes, I'm going to cut you off. I don't care whether you're in the middle of a sentence. I'm not going to be polite because I can't be. Just to set the stage, that's what it is. Yes, go ahead.
Policy in public meetings, about not repeating what previous people have said. Is that easy to enforce or not? How do you feel about that?
The question is, could you prohibit someone from not repeating what someone else has said? That may get you into a little bit of a tricky spot because, again, the idea of public comment, if you're inviting the public to come in and to share their feelings, so why are my feelings on this less valuable just because someone else had them beforehand? I do see, town meeting is something else, just for anyone who's wondering. It's not subject to the same rules. So the moderator at a town meeting can certainly say we're not going to hear repetitive testimony or something like that. But at a public comment period, it could be problematic. Yes?
In certain instances, a previous speaker may have provided, a speaker might have given a comment in, but then they notice another speaker coming, a commenter coming in and giving a particular input that may seem incorrect or confusing or needs what is the right procedure for chair either to invite, maybe the chair doesn't know that they have to invite, but for the commenter to reach out beyond the public period to be able to say, this something needs to be done to correct this, or this is a particular input that needs to be tagged along with that input or comment.
So the question really is, what if someone makes a comment that really needs clarification or that should be clarified or that's wrong? And my answer to that is that the public comment period is not a time when the town is endorsing or agreeing with or disagreeing with what people are saying during public comment. Public comment is for the public. And Joe, I know I'm making you dance all around, but let's just go to the one after the, let's go to the next one, yeah. So what we advise to avoid potential liability issues and to essentially allow the board or committee to actually conduct its meeting is to avoid debate during public comment. There's no reason to respond. This isn't something the public body is taking in to rule on or to act on. It's just simply a listening exercise. Avoid responding to comments before the board has had a chance to talk about them. A lot of times at public comment, something new is raised and one member might feel like they know all about it, but the rest of the members might not. That's another reason not to get into debate. It can feel funny in a world where we try to resolve everything, but we really encourage public comment issues to be left unresolved. There is no obligation of the board to put, to set things to rights as part of that public comment period. Certainly, and this is something that you had asked, if the chair believes that something needs to be clarified or addressed, the chair can put it on the agenda for the next meeting. And then anybody and everybody who's interested in that can come to that meeting and either participate or listen to the board's presentation at that time. Going back and forth with people at public comment can also lead to kind of a degradation of the tone and tenor of the board's meeting. If people are being critical, and that is their right, let's be serious, that's what is protected. They're allowed to come in and petition the government. As board and committee members, it's hard not to take it personally, but it's really an opportunity for those people to speak. And not a responsibility or an obligation of the person who's sitting there to defend what they've done or to, champion what they've done. It's really just for them to listen. And that can be hard, but when you don't do it, and I'm sure you've all been at meetings where someone's gone back and forth with a board member and everyone else is kind of rolling their eyes, like, why are they so worked up? But that's something you want to avoid. There's no point in that. And then for people who have more to say during a public comment period, encourage them to email or to make an appointment to meet with the chair or an appointment to come before the board. There are lots of opportunities to interact with government, not just during a public comment period. And then finally, another thing that a lot of boards do to deal with things that kind of head off into the category of employee performance or whether my garbage is being picked up correctly or whether there's a pothole on the street. Again, the board isn't going to be able to solve that problem, so lucky for Paul, we can just refer it all to Paul and let Paul handle those things. So I gave you some of the, and my time is definitely up. I like to talk too much. I think I'll let you look. The board has part of their policy I put in here on public participation. I gave some other examples of public participation. And the one thing that I just wanted to point out is that unprotected speech and disorderly conduct can be curtailed. Speaking without being recognized, continuing to speak after the chair has said to stop, interrupting a recognized speaker, speaking about matters that the board has no jurisdiction over, speaking over a recognized speaker, talking amongst yourself while someone else is talking. Those are all reasonable time, place, and manner restrictions. And again, the chair has that authority under the open meeting law to say you need to stop that. If they don't stop, they get another warning. And in theory, you could have them removed from the meeting. In practice, that is a pretty significant action to take, and I really think more often than not, people will take a break. They'll take a recess to try to let cooler heads prevail. There are some limited types of speech based on the content of speech that can be curtailed. True threats of violence, and that really means a person making a threat to another person that person would reasonably believe could occur. So just saying, you know, I hate all the people in this room. Not that I would ever say that. That is not a true threat of violence. Or, you know, I will make every person in this room leave. Not a true threat of violence. But if I look at a particular person and I say something threatening to them, that is probably enough to curtail. Comments inciting imminent lawlessness. And if you have ever heard, and I'm sure you have, like someone yelling fire in a crowded building, that's the kind of thing that you can stop. Using fighting words. The courts have been pushing back and making that a narrower and narrower category. But again, somebody who is being really aggressive, they might fit into that category. And then using that public comment period for harassment, which is more than just saying something negative. It's intentionally causing a particular person harm at that time. Those are very narrow categories, and it is highly unlikely that that's something that you would experience on a regular basis. It is much more likely that the speech you hear at public meetings is protected speech. And so really for chairs, understanding what those reasonable time, place, and manner regulations are and how to use them as the way to manage that. You had another question.
So does hate speech fall under harassment?
Hate speech is a very narrow category, and in fact, in the Barron case, and I'm happy to point you to the actual case because the recitation of facts is really pretty useful. There's a threat made against people of a particular religious background, and it's not, maybe it wasn't perceived as a threat made by everyone, but certainly some people would think that, and the court said that's not protected speech. That's not unprotected speech. That person could say that without a problem. So, kind of having, and it's hard because you're already giving of your time. We heard so much about all that it takes to be a volunteer for our town government. But in a lot of ways, you have to have a thicker skin. And it, again, to use the tools that you have that are available to you in your toolbox to curtail unwarranted kind of disturbances of the flow of the meeting. Someone being rude, someone yelling, someone saying you guys are criminals or whatever, that is not going to be something that you can curtail unless they're speaking over someone, they're not waiting their turn, they won't stop talking when their time is up, that kind of thing. So looking through this will give you some good ideas, and certainly if people have questions afterward and you send them through Paul, we're happy to try and provide some more guidance. Yes?
Where are you going to post these slides?
We're going to send them to Paul in the morning, and then you will have them. Okay. Yes. Okay. Whew, I'm tired now. No. Since Joe has been so good about doing the slides this entire time, I'll do the slides for him, and hopefully he's going to talk about social media, which is much more exciting. So, Joe, thank you.
So I have the pleasure of being third in line here, which means everybody's eyes are already glazed over, and I do my best. As exciting as this is for those of us that work in the field, after a long day, I imagine at some point it becomes a little bit. But do appreciate you having us all here tonight. We can go through some of these important topics that you're all facing on a regular basis. The focus of my presentation is on social media and the interplay it has with the open meeting law, public records law, and the First Amendment issues. Now, personally speaking, I'm not a big social media user. I have my own personal opinions and how it's affecting our civilization these days. But At the same time, that aside, and the negatives that come out of it, there are a lot of positives that come with social media, and particularly in your line of work and what, getting messages out to the public, information out to the public, to some extent interacting with the public. Social media can have a very, big effect and serve as an important tool to getting, your work essentially and the information you want out to the public. Now, social media, this particular area of the law is constantly evolving. The platforms are continuing to evolve. They do provide opportunities for individuals to comment on the posts, to share information with one another, both yourselves as well as members of the public. And what we have to be careful of as public officials is not only in your professional lives, how you're using social media, but also in your personal lives, unfortunately. So we've talked a lot about the open meeting law, so I won't, bore you with too much of that, but, all your bodies, public bodies are subject to the open meeting law. It's a broad definition, includes subcommittees, committees, boards. We've already gone over the requirements for posting and holding meetings. One of the things that we didn't talk too much about, though, is your deliberations and the context of those deliberations. All of them must occur at properly posted meetings, and this is particularly key when we start talking about things like social media, or we're talking about use of email, text messages, and things like that. And so when we're talking about deliberations, it's basically when we're discussing matters within the board's jurisdiction. And it's broader than just things that we might think of as like votes or particular topics that might be before you. Anything that where you're sharing, board members are sharing, their feelings, their thoughts, their ideas on topics that are before you or could come before you become problematic. We're not talking about things like scheduling and ministerial matters like that. And the Attorney General looks at this pretty rigidly. There's not a lot of wiggle room for what you can do as board members, whether it be through email, text messages, social media, where it's sort of offline. Much of everything is really going to need to be constrained to the public meetings that you're holding. And you also have to worry about, when we're talking about social media and some of these other forms of communication, of serial communications. So it's not necessarily where everybody's necessarily on the same email, for example. It could be one member sharing with another member who then shares with a third member. Those are the types of communications where you can get yourself into open meeting law violations, even though they may have started innocently enough, your intentions, but once you start creeping in and involving a quorum of your board, then you really are getting yourself into open meeting law violation situations. So focusing now on social media aspects. So as we know, there's all different formats and platforms that are out there. Some involve or permit direct messaging between users of the platform, posting for the public or otherwise, or blog posts and things like that. And in many cases, those can be viewed by the public and subsequently responded to or reviewed, not only by the public, but also by your individual board members. So when we have these types of discussions and we're utilizing social media, this is where the open meeting law, the public records law, and the First Amendment all kind of collide. So when we're weighing in, when two members of your 5-member board, for example, have already commented on a post, that would be considered deliberation on social media. Responding to a post by another member of your board or committee with your own thoughts and ideas and feelings, also a deliberation. Directing your fellow members to a post whether it's tagging them or otherwise, I guess, alerting them to information that you've put out there. Again, that's a deliberation. So when we're looking at social media and the open meeting law, some of the practical considerations to consider is not direct commenting to other members of the public body, just eschewing that altogether. If the matter directly involves an issue that's pending before the body, don't engage. And this is particularly true if you already have, one of your members that's already kind of weighed in. You want to think about the comments that you're making at the time. It may come off at the time that you're just innocently enough and it's just a reaction to something that a member of the public said. But unfortunately, in some cases, they may actually be even calling you out. And so there's that temptation for you to want to respond to it in real time because you don't want that to just sit out there like a lead balloon for everybody to see and they're throwing shots at you. And I think as Lauren just mentioned, there is a part of your job that does require you to have a thicker skin. It just comes with the territory. So, one of the things that, sometimes you can do with that is essentially respond, but without responding in substance, by saying something along the lines of, that whatever their opinion is their opinion, and, I'll be happy to share my thoughts with you at the board's next meeting, which is scheduled for X. Now you're not sharing your thoughts and ideas on the particular comment, but you're also indicating that, that's not necessarily the end of the discussion for you, that you have more to say on it, but you're not going to do it in that forum. For those that are running for an office and then are subsequently elected, we do suggest consider having separate social media accounts. Because one is as you're campaigning, that's your campaign account, keeping that separate from when now you're on the board or committee, and now that's your official, if that's how you're going to interact with the public as that member, is have that. Or in the case of if it's more of a town-sponsored site, it might be for your particular board or committee. So trying to separate out sort of your private, in the campaign context, versus your official capacity where you're now dealing with matters that are coming before your particular board or body. And we've already touched on the due process issues, but keeping in mind that people do have due process rights, so what you're putting out there or what you're discussing in social media and whatnot, you may be inadvertently infringing on somebody's due process rights. Yes, question? So the question is on social media whether a like or some use of some sort of an emoji considered a comment. And for purposes of the open meeting law, when we're talking about board members, it's an expression of your thoughts and feelings on whatever it is that was posted there. So yes. So even just giving the old thumbs up to a post, unfortunately, if you have multiple board members that are giving the thumbs up to a particular thought, you're essentially now involving a quorum of your board and expressing as a board what your opinion on a particular topic is, and you've done it outside a meeting. Yes, sir.
If you're in a organization, in a group on a board, and members of that same board are part of another group outside of that board, say, you're in a group about like pet animal rights, and then there's animal health group on the side, right? Then those two groups share the exact same, share some of the same members. And you're talking about similar issues. I mean, how do you avoid that without just saying, oh, I'm only involved in this one group and that's it?
So. Yeah, you have to tread very lightly. So the question is if you have your official group that you're on a committee or a town board, and there are similar members that belong to a sort of a private entity, but has similar, I guess, interests, if you will. So conservation, let's use that as an example, I think is kind of comes to mind for me. So you're on the Conservation Commission, but you're also part of some other organization, or you work with some volunteer group that cares a lot about the environment and deals with environmental issues, and you have some overlapping members. The difficulty you're going to have when you start chiming in either setting really, is are you involving essentially a quorum of your board that you're now expressing opinions to? Are they matters that are coming before the board or that could come before the board, as opposed to whether or not we're all going to participate in the latest, the fundraiser for, I don't know, XYZ fundraising fair for this private entity, right? So that's outside the Conservation Commission scope, so it's more clear in sort of its topic as to what you're speaking on, whether you're speaking as a Conservation Commission member or as somebody that's interested in this outside group. But you can see how those waters become very muddied very quickly. Now, you can to some extent qualify that you're speaking as an individual and not speaking on behalf of the Conservation Commission. But even then, you're sort of at the same time identifying yourself as a Conservation Commission member. And so when we're dealing with some of these, it becomes a tricky issue. So, my general advice would be, if it's something that theoretically could be coming before the board, don't post privately, don't post publicly. Just, I guess you can share your comments. It's some other opportunity. But in some ways, if there's going to be that overlap between the two, it's going to be very difficult, if not impossible, for you to separate the two roles, at least as how a member of the public is going to view that.
Mentioned the Trump case may also factor in the Trump case.
Right, and I'll
Yeah.
be getting to that.
Just so that you flag it, yeah.
I have a question.
Sure.
Say for a particular committee, there is material out there that's interesting as a read, as a general read, kind of not to make a post or a comment, but as chair or as a member says, hey, here's a new article on how green algae eats PFAS in the community, right, or grass, or whatever it is that they say. Read up on it, and here's some info for your reading pleasure. No comments, no discussion, just for your reading. It's new scientific research published in British Science.
Yeah, if we're talking about something that's outside of the scope of whatever, so for example, if we're talking about a Board of Health, right? If we're talking about a Board of Health where there's a particular subject that's coming before the Board of Health, that's going to look different potentially to a member of the public in your communications, because what's going to happen potentially, you post that and your other members may respond. That's just the potential that opens up for. But if we're talking about just something generically that's just informational, that it's not anything that's before you, that's not really an issue.
But it could become, the Conservation Commission or somebody may be saying, hey,
Well,
do that. But it's just background material if you're saying, here's something to read. Don't, and all the members know not to comment on it publicly.
That's the key point. That's the
If
key
they know
point.
that, then that's okay.
Yes, yes.
Straight answer from a lawyer, what do you think?
If with that qualifier, of course, because if they know not to respond, because that's a big part of this, right? It's when you start posting on social media and folks start having a tendency to want to chime in. It works great if everybody's on the same page, and that's the caution. It's not saying don't do it, but it is a caution that we put out there for folks, because in that particular case, maybe there's a universal, I guess, opinion on that information. But sometimes we'll post information like that we're saying it's informational, but there's somebody on the opposite side of that issue that finds that information to be misleading, and then now we've involved ourselves in a whole, online discussion. So, I just want to touch quickly on the components of the public records law. So if you are posting on social media in your official capacity, you have to ensure that the post is retained in accordance with the law. There are certain features on different platforms that allow for you to retain or archive, or you could take a screenshot of the posts. If you have responsibility for managing a town social media page, you need to confirm that that page is being retained in a manner that's consistent with the public records law, and that if a public records request is made and the subject was also addressed in the post is also responsive. So when they're looking for documents discussing XYZ topic, it's not necessarily the emails or the board's packet information. It could potentially be social media posts, depending on what the subject was. And deleting a post could rise to be a constitute violation of the public records law if it is something that should have been retained. So what Lauren was sort of alluding to is when we start getting into the Trump case and another case that we'll be talking about, is where the social media now starts to overlap with or interact with the First Amendment. So there are a certain amount of First Amendment protections, no different than when we talked about earlier the public comment part of this proceeding. When you have a social media page, you can't limit a person's access to the page or their interaction with the page based on the content of their speech. So similar when we talked about public comment, you can have a particular set of rules that you're applying. We'll talk a little bit about that in a moment, but you can't be basing those rules off of the content of their speech. And there are different levels of, I guess, protection that apply to the regulation of speech based on whether your social media platform is a public forum or semi-public or it's private. And if it's a public forum, then that's where, is similar to what Lauren mentioned a few moments ago, when you invite the public in, they have greater First Amendment protections at that point in time. All of this that we've been talking about with these First Amendment, public comment, et cetera, they're all very, very fact specific, so it's hard to give you blanket answers for all these scenarios. But a lot of it will, there's certain commonalities that we would look at as whether or not the person is speaking on behalf of the public entity, whether or not how they're using that authority. We suggest, yes?
Just a question about posting and allowing comments and things like that. If a board or committee has a social media account presence that they typically share information, are you allowed to, so I understand they cannot restrict commenting based on the content of the commenting, are you allowed to do something like turn off commenting for all, so nobody can comment?
Yes, yes. There's a, I'll jump in a little bit later, but you can have certain settings as long as you're applying those consistently across the board, where you could essentially have your town social media page be more or less like a bulletin board, right? Where you're posting out, but you're not inviting the public to comment back in. That would be fine. One of the things that we do suggest when we're talking about personal social media accounts, because there are a lot of folks that when you get into your positions, you have your board official page, you may or may not have your own personal official page. Many folks will use their personal Facebook accounts or what have you to comment on things that are also happening and sort of overlap with their roles as a member of a board or committee. That gets dangerous for you because you're now potentially using, or you really are at that point, starting to convert what would be a personal account, like a private forum, and now you're engaging the public on matters that are really in your official capacity. So one of the things that you can do to help yourself in that regard is use a label like we have here, that this is a personal account and is not intended to, nor does it constitute an exercise of my authority as a member of the X board, planning board, conservation commission. If you would like to like me if you would like to provide input to me in my official capacity, please visit my public page here, and you can sort of direct them to another page, and keeping that clean. Now, easier said than done, I understand, but that's where if you're really trying to steer clear of having your personal page be dragged into some of these First Amendment issues, these public forum type issues, you really want to keep those areas separate from one another as much as humanly possible. Lauren had mentioned a moment ago, there was the Knight First Amendment Institute at Columbia University versus Trump. And basically what the Second Circuit Court said in that case, that when a government engages in an interactive manner with the public on social media by making official communications on a wide variety of subjects to which the public is able to respond or engage or comment, et cetera, you are basically creating a public forum. And by creating a public forum through a social media page, the court said it violates the First Amendment when the government official excludes persons from the dialogue because they express views which the official disagrees. So we're talking about deleting comments, blocking people. Once you open up that forum as a public forum, essentially the First Amendment is giving them the right to interact with you in that public forum, whether you like it or not, and you blocking them or deleting their comments but allowing the favorable comments is essentially posing a risk for yourself as well as the town for First Amendment civil rights violations. So, if we have an official social media page for the town, and if we're going to allow comments and reactions where they're allowed, the bullet points that you see up there are the things I just mentioned, where you can't block, you can't ban, you can't mute, you can't turn them off, you can't delete them. And if someone requests to follow or become a friend of the page, they have to be permitted access to the forum. They can't be excluded because we happen to know that they affiliate with some other organization that maybe we're not too keen on. It's a public forum. At that point, it's open. There may be some limited exceptions, again, when we're talking about threats of violence and things like that, where we can place some limitations. But again, once you're opening that up to a public forum, it's pretty limited in what you're going to be able to restrict. Alternatively, and this was to the point of a question earlier, if social media page is not used as sort of an interactive dialogue with the public, and it's used more like a town bulletin board, well, then you can limit, you can take certain steps. So you can ensure the page is accessible to all. It's not private, so you're going to be creating a bulletin board that's public but not exclusive. But you can turn off the comments. Now, you want to do that before the page is launched. So one of the things that we run into from time to time is clients will put these pages up before, without any kind of, just trying to communicate with the public, and then they run into a problem because of the nature of some of the comments that are posted, and they could be offensive, they could be disruptive, they could be all kinds of things. What do we do? And it kind of limits you at that point, because if you now just shut off the comments, it's essentially going to appear, and maybe not even appear, it's going to look like this was the intent, to shut off comments because of that person's speech. So that what you've essentially done is you've reacted or retaliated against them as a result of their speech. So, if you're going to turn off the comments on a page, I guess we want to make sure that you're not doing it in close proximity, time-wise, to where someone is posting something that would be considered controversial or something that might be offensive, etc. You want to designate a town employee for somebody that's managing the page, setting forth the parameters. A lot of towns will have a policy that sets out if we're going to have a town, each department's going to have its own webpage, what's going to be posted on there, the types of information we're going to put out there, who's going to be responsible, who's going to be the one that we're submitting the post to, so you have some consistency in things. Now, what you have to be careful about, though, is that we can't agree to post information from one non-public source, but then refuse information from some other non-public source. So some community group not affiliated with the town wants to post something on the town's webpage, just advertising whatever event they may have going on. Once you open that door, you're opening really to everyone that wants to utilize the town's bulletin board or Facebook post, Facebook page for that same purpose.
So, sorry.
Yes.
So if you have a website and say a group comes before the board and they deliver a presentation and they ask if a link to their presentation be put on their website, right? Put on the board's website. Does that mean that in the future you would have to, for whatever group that comes in front of the board, you would have to put a link to their pages on your website?
Start a chain.
What's that?
You'd start a chain of events.
Right. So there's a, if we're talking, you're talking about the website, like somebody made a presentation to the board. The question was, what would happen if someone were to provide or give a presentation to a board and they have a slideshow, for example, and they want to include a link on the town's website to their slideshow, and whether or not that would be permissible or not. It exposes you to the same types of elements or similar elements, because at that point in time, you're starting a chain, as Lauren mentioned, that now if somebody has an opposing view, they want essentially equal time on your website to show why this project is not good for the town. So when you're dealing with somebody from the outside that's being allowed access to your public forum, however you're choosing to do that, once you're starting to allow interaction from those on the outside and they're using your platform to essentially interact with the public, you are going to open yourself up to that from other groups.
The one qualification is if someone's making a presentation to you about something that, like for an application or something like that, then their presentation is part of the record, and that's a different thing.
Yes, and that's not what I understood the question. If that was the question, I misunderstood. Then okay, yeah. If we're talking about like the minutes of the meeting essentially, or what happened at a meeting, so for example, there was as Lauren said, somebody's coming before you to, they're seeking a permit, and they have a slideshow presentation relative to that, and they present that at the board meeting, and then the board, as part of its, I guess, record of what transpired there, wants to post essentially for the public to see, because you post the recorded meetings, you post the minutes, and you're posting a copy of their presentation that was given at a public meeting. That's different. I think that's what Lauren's distinguishing between two. As opposed to something that's not a matter that's before the board and you're not being asked to act upon, they're just asking essentially to use your platform.
The actual experience that I'm thinking of is we had somebody who came in front of the group, they delivered a presentation, the board liked the presentation and kind of wanted to endorse it in some way, to the extent possible. And that is the endorsement, of that group's goal on the website, constituting the need to put anything on the website.
I would say yes. I mean, yeah, I'd say yeah, as Lauren said, it's a slippery slope at that point, because, and the question was whether it wasn't a particular permit, but the entity came before the board, did a presentation, and the board was favorable to it and was looking for the board to essentially endorse the presentation that they had given. And again, that's when you're now opening yourselves up for other folks that want to come before you, and now they want to make their presentation, and they're asking for your endorsement, but you don't like their program, or you don't like theirs. So it's turning you into a platform for people to come in, have a wider audience, use the town's website, which will be, somewhat well-traveled by residents, to get a message out, which is different than I think what Lauren was distinguishing, which is that when you're dealing with like a public hearing and there's an actual presentation relative to that's relevant to the public hearing that they presented.
Pause for just 1 second so I can switch batteries, please.
Sure. If they're, right, so just in that quick break there, so just another clarifying, again, this is where we say earlier that everything is fact intensive with these cases, that if it were a situation where the board is adopting as its own policy, that it is essentially adopting for itself a particular position or on an issue, albeit it may have initiated from the outside, but now it's going to vote to adopt it as its own, then that may then convert it to essentially government speech, and it's speaking, the board is essentially no longer allowing a platform for others to come in and advertise their positions or what have you. They're saying, this is our position. And so they've adopted it as their own. Does that make sense? I know it's a gray area.
Maybe I'll come back after and
Yeah.
get a clarification.
Sure. So this brings us, there was in March of this year, there was a U.S. Supreme Court case, Linke versus Freed. Now, this particular case arose when the city manager in Michigan deleted from his Facebook page critical statements, photographs that was posted by the plaintiff concerning the city's response to COVID. He then later blocked him from accessing the page, and at that time, he had primarily used that particular page to post updates on his personal life. That's how it initially started. It was just a personal Facebook page. But over time, it morphed into he also used it at times to post about his job, developments in the city, information about projects, et cetera. And so after he blocked the plaintiff sued him for violating his free speech rights under the First Amendment, claiming that essentially the city manager had created a public forum with his own personal Facebook page. And he couldn't treat posts that were critical any differently than those that were favorable. And that essentially by deleting them and blocking them, he engaged in essentially a violation of his First Amendment rights. Now, what the court ultimately concluded in that case is that even on a public official's personal social media profile, that a municipal official may engage in governmental action and there, as a result, be subject to the First Amendment. So it can transform, as I said earlier, your personal profile, a personal social media page, to one that constitutes governmental action. They set out a two-part test, which is a little complex, but essentially to determine whether somebody's acting in their official capacity, they looked at whether the official possesses actual authority to speak on the municipality's behalf. Obviously, the city manager in that case did. And the municipal official purports to exercise that authority when posting on social media. So when both of those conditions are met, then a municipal official's personal social media profile can be considered a public forum, and at that point, you can't limit the public's access to that. You can't delete comments and start blocking people from it. There's more, it's a little bit dense in here, but when we're talking about the actual authority to speak for the municipality, and you'll get copies of these slides, but in the interest of time, I'll just run through them quickly, but it's whether or not a public official has the power to represent the public body, such as codified authority to make announcements for a body. There's a permanent and well-settled ability to do so, even if it's unwritten, or in the case of some higher-ranking officials with broad responsibilities that reasonably encompass authority to speak officially is an implied authority. So a board of selectmen, for example, they're the chief executive of the community, they would fall into that high-ranking authority. Now, and where it exists, it may extend to the official's public or personal social media account, even if it's not explicit. And the actual authority to speak on a matter exists not when the authority could be part of their duties, but when the facts show that it actually is. So it's not so much a hypothetical as much as an actual. And on the exercise of that authority, the other part of the test is that even when you have that actual authority to speak, they have to be purporting to use that authority to trigger the First Amendment concern. So the point of this presentation, this piece of it, was not to scare everyone to go home and delete all your personal social media accounts, but to at least make you think about how you're utilizing your personal social media accounts when it relates to town business. Because you're not, as noted here in the slide, you're not prohibited from speaking as private citizens as long as you're acting in your private capacities. And again, whether or not it's...
Have your attention, please. The library will be closing in 15 minutes.
Yeah. Feel like I'm at the Oscars. The music is playing.
Be sure to save your work before that. The library is closing in 15 minutes.
So whether or not it's private or not does remain a fact-specific analysis, but the court did find that a disclaimer or a label that a social media account is personal, or that you're merely sharing on social media information that's available elsewhere, could support a finding that was private. On the flip side, a label that clearly identifies the account as belonging to a public body or a public official in their official capacity would support a finding that that account was public. So you kind of have to think about how you're labeling your social media accounts and what you're putting out there on your page as to who you are. And then how you utilize that page, after in the context of the things that you're putting out for the public consumption. I think for purpose, the next slide is really just a lot more of the same. So some of the considerations to put out there. I know in the interest of time and in light of the library's announcement, I want everybody to be able to go home. But if anybody has any other questions, I'd be happy to answer them. Yes, ma'am.
I have a question about site visits. When a committee has decided they need a site visit, does it need to be posted? Do you need a quorum? Do you make a decision?
You want to jump on that one, Laura?
You want to run away from the podium? So the answer is you cannot post a site visit as a meeting of the board. You can't force a private entity to allow a public meeting on that property. However, you are not allowed to deliberate at a site visit. And so what that means is if you have a talkative board member, and we all know you do, that you may consider going in a staggered way, or you don't drive together, you don't drive home together, and we always suggest that you, if you want to point something out, you don't say, oh, look, there's a pile of sticks in the buffer zone. You might just say, I just want to bring people's attention to this pile of sticks. And then post a meeting for right after your site visit, and go back there and talk about all the things you saw and what you think it means at the posted public meeting.
And then make a decision at a posted public meeting.
And make the decision at a posted public meeting, correct.
Any other questions? All right, well, we want to thank you all for your time tonight and your patience in listening to us. And we are available. We'll be forwarding the slideshows to Paul, so you'll have access to them. Thank you very much.